and also I'm the chairman of the seminars, workshops and programs committee of the OPA. I will be your compere throughout the session before the moderating takes place. President of the OPA, Mr. Lalanath, Attorney at Law. President-elect, General Secretary of the OPA, Mr. Lalanath De Silva, the President of the Bar Association of Sri Lanka, Secretary of Bar Association Sri Lanka, Mr. Chathura Galahena, Attorney at Law, and our keynote speakers, past presidents, vice presidents, and forum members of the OPA, the council members of the Bar Association Sri Lanka, dear ladies and gentlemen. Will you, in a time where the silence can sometimes speak more than the voices, and where the strength of a nation is tested not only from law, but also with the enforcement of law, with the proper upheld of the law. Tonight, we speak about the rule of law and the protection of individual human rights, not as a theory, but something that affects every citizen every day. This seminar is a joint effort by the Organization of Professional Associations of Sri Lanka and the Bar Associations of Sri Lanka, the two bodies committed to professionalism, justice and truth. I and we also as a committee, seminars committee, truly honored to organize this seminar in this evening. So let's begin now. I invite President of the OPA, Mr. Lalanath, Attorney at Law, to formally deliver the welcoming speech. Over to you, sir.
President-elect Mr. Asanga Gunawansa, General Secretary Mr. Asanga De Silva, past presidents, office bearers, President of the Bar Association of Sri Lanka, Mr. Lalanath De Silva, President's Council, our eminent guest speakers, members of the Executive Council and General Forum, ladies and gentlemen. It gives me great pleasure to welcome you all to this seminar on the rule of law and the protection of individual human rights, organized jointly by the seminars, workshops and programs committee of the OPA, together with the Bar Association of Sri Lanka. As a lawyer myself, I am aware of the importance of this subject, as the rule of law and the guarantee of human rights are essential components of a just and successful society. As you may know, in Sri Lanka, the rule of law and protection of individual human rights are enshrined in the Sri Lanka Constitution, particularly Section 3, which declares the sovereignty of the people and divides power into executive, judicial and legislative branches. Chapter 3 of the Constitution guarantees fundamental rights, including freedom of thought, conscience, religion, and equality before the law. The importance of an independent judiciary is also recognized by the Constitution. Furthermore, the enforcement of these rights is guaranteed under the Constitution, which gives the Supreme Court sole jurisdiction to hear cases related to the infringement of fundamental rights. Despite these laws and robust mechanism, significant areas of concern remains. These include counter-terrorism laws, such as the Prevention of Terrorism Act, which can infringe on fundamental rights, restriction on freedom of expression, and impunity for human rights abuses, which cases of torture, corruption, and abuse of power going unaddressed. At a time when the present government has pledged to address these concerns, this subject has become more relevant than ever. We are jointly today by two eminent guest speakers who are experts in this field and who will be able to provide greater insight into this critical issue. I am pleased to welcome Dr. Asanga Gunawansa, President's Counsel and Dr. Lalanath De Silva, Attorney at Law. Thank you being with us this evening and allowing us to benefit from your knowledge and perspectives. This seminar will conclude with a Q&A session that is designed to take an interactive format where you will have ample opportunity to pose questions to our speakers and learn more about this subject. I know you must be eager to hear from our speakers, so let me conclude my speech by wishing you an informative and enriching seminar. Thank you.
Thank you, Mr. Dahanayaka, for those thoughtful welcome remarks and for setting the tone for the important discussion. To officially open today's conversation, we are honored to hear from a leading figure in Sri Lanka's legal community, Mr. Anura Maddegoda, President's Counsel, President of the Bar Association of Sri Lanka. Mr. Anura Maddegoda, President's Counsel, an eminent lawyer in the areas of public and criminal law and has over 40 years of active practice in the legal profession. He has previously served in the Attorney General's Department as a senior state counsel for nearly 20 years. Thereafter, he joined the Office of the Prosecutor in the United Nations International Criminal Tribunal in The Hague, the Netherlands, as a prosecuting trial attorney and legal advisor in 1994 and served for 10 years. He also served as the Deputy President of the Bar Association of Sri Lanka in 2021-2022. He was also elected once more as the Deputy President of the Bar Association. Mr. Maddegoda was very much in the forefront of the Bar Association's stand on the rule of law, the independence of the judiciary, and protection of the rights of the people. A former chairman of the Consumer Affairs Authority, he has also served on the board of directors of Sri Lanka Insurance Corporation, having been appointed on the directives of the Supreme Court. President Counsel Mr. Maddegoda holds a Masters of Law in International Law from King's College, University of London, and graduated with a merit in 1991. He is an All Boys of St. Thomas's College, Mount Lavinia, and a member of the Executive Committee of the St. Thomas's College, OBA, and has served as Vice President of OBA. He presently serves on the boards of well-known insurance and pharmaceutical companies. So please join me in welcoming Mr. Anura Maddegoda, President's Counsel and the President of the Bar Association of Sri Lanka, to address the gathering. Over to you, sir.
President of the OPA, my friend Sujivalal Dahanayaka, and the other office bearers of the OPA, and also my colleagues in the bar, Dr. Lalanath De Silva and Dr. Asanga Gunawansa, and ladies and gentlemen. There's also, I must acknowledge, the presence of the immediate past president of the OPA, also a lawyer, Ms. Ruchira Gunasekara. Also our Secretary of the Bar Association, Mr. Chatragal Hena, is also present with us this evening. I must first of all, I'm quite delighted to having been invited to be part of this session on the rule of law and the protection of individual human rights from the perspective of a litigator and also from the perspective of alternate dispute resolution and mediation. So we have two eminent speakers from the two areas, experts in the two areas who are with us this evening. I'm also very happy today because this year we celebrate not only 50 years of the OPA, also we celebrated 50 years of the Bar Association. It was in 1974 on the 11th of November 1974 that the Bar Association of Sri Lanka was formed, and we completed our 50 years, the Golden Jubilee anniversary in November, and we had a felicitation to felicitate the members of the Bar, to felicitate also the other jubilarians, lawyers who have completed 50 years of active practice just 1 month ago. So it is very, I believe, fortuitous that we have today, we have the opportunity to have this seminar on the rule of law and the protection of individual human rights in conjunction with the OPA, and I'm thankful to the chairman of the seminars committee for having organized this event this evening. As far as I'm sure the two speakers will be introduced, but if I may very briefly, Dr. Gunawansa is an attorney at law, is a President's Counsel, having been called to the bar over 30 years ago. He and I served in the Attorney General's Department for a long time, after which Dr. Gunawansa took wings to Singapore, and he was in the National University of Singapore. Today he holds a doctorate in law from the NUS, and also he has a Master's of Law degree from International Economic Law from the University of Warwick in England. He is also the head of chambers of the Colombo Law Alliance, a law chamber specializing in commercial law, legal aspects of project financing, foreign investment law, construction law, and arbitration. Dr. Gunawansa is also a member of the National Procurement Commission, and until recently headed the Interim Secretariat for the Truth and the Reconciliation Mechanism of Sri Lanka as its Director General. He is also a visiting professor at the University of Moratuwa and a member of the Board of Studies of the Council of Legal Education of Sri Lanka. Dr. Gunawansa is also a visiting judge in the Court of Appeal of the Republic of Fiji and an advisor to the Green Climate Fund, where Dr. Lalanath De Silva, our next speaker, our other speaker, has a vast amount of experience. Dr. Gunawansa has also worked with the United Nations and also with the Senior Research Associate of the National University of Singapore Institute of Water Policy of the Lee Kuan Yew School of Public Policy. He is an executive committee member of the Asia Pacific Center for Environmental Law of the National University of Singapore. He is a fellow of the Singapore Institute of Arbitrators and a distinguished panel member of the Thailand Arbitration Center and a member of the special panel of the Singapore International Arbitration Center. He is also an arbitrator with the Asian International Arbitration Council Center, Hong Kong International Arbitration Center, and a SAARC Arbitration Council. Dr. Gunawansa, on behalf of the OPA and the Bar Association, let me welcome you most warmly to this seminar. The other speaker we have today is Dr. Lalanath De Silva, whom also I have known for a very long time. I believe for nearly 40 years or more. We've been at the law school at the same time. Dr. Lalanath De Silva has been a very strong proponent of public interest litigation in this country, and also particularly in the field of environmental law. He was a founder member of the Environmental Foundation of Sri Lanka, and presently Dr. Lalanath De Silva he was the first head of the Green Climate Fund, Independent Redress Mechanism. He is also a panel member of the Independent Complaints Mechanism of the International Climate Initiative of Germany. Dr. De Silva has also served as a consultant to the Ministry of Environment and also been the architect of many statutory instruments of Sri Lanka, particularly in the field of environmental law. Dr. De Silva also served in the Environmental Claims Unit of the United Nations Compensation Commission in Geneva and served as the director of the Environmental Democracy Practice at the World Resources Institute in Washington, D.C. As a member of the Compliance Review Panel of the Asian Development Bank, he led the review of multiple compliance cases. Dr. De Silva also holds a Doctor of Philosophy degree from the University of Sydney, and also a Master of Laws degree from the University of Washington Law School, and graduated with honours from the Sri Lanka Law College. He is also a trained mediator. A lesser known fact about Dr. De Silva is he is a composer and conductor with several orchestral, choral and chamber works to his career. Let me also welcome you on behalf of the OPA and the Bar Association. Let me welcome you, Dr. De Silva, to this evening. And we look forward to very fruitful engagement with the audience, comprising a lot of professionals who are here and also a few lawyers. And I believe we will have the benefit of your expertise in the field, in the subject of rule of law and the protection of individual human rights from a litigator's perspective, which will be the focus of Dr. De Silva's presentation, and from the perspective of the alternative dispute resolution and mediation, which will be the subject of Dr. Gunawansa's presentation this evening. Thank you.
Thank you, Mr. Lalanath De Silva, President of the Bar Association of Sri Lanka, for your compelling message onto the audience, and also introducing our keynote speakers in this evening. Yes, as introduced, next we will begin with a respected legal voice. Our first keynote speaker, who has made a mark both locally and internationally in the field of human rights. Please welcome Dr. Lalanath De Silva, Attorney at Law, to speak to us on the protection of individual human rights. Over to you, sir.
I'm just setting my watch so that I don't go on for longer than I have to. Good evening, everybody. And thank you for inviting me, the President of the OPA, Vice President of the OPA, and as well as Lalanath De Silva, whom, as he said, we've known each other for a very long time. Thank you for that introduction. And welcome that I have received before coming here. Thank you for all of that. I really appreciate that. And I'm also happy to associate myself with my longtime colleague, Dr. Asanga Gunawansa, who will speak after me on some relevant aspects. I would like to focus today on a number of different things related to human rights and the protection of human rights in Sri Lanka, but also around the world. But before I do that, I do want to raise an important question, which is, if I were to ask you where in the world does impossible things happen, you might answer me saying it's probably in the United States, where things are really going very badly at the moment, perhaps for some, and sometimes others would say it's going really well, but things that haven't happened before are happening in the United States. Or some others might say it's in Ukraine or in Europe, where they're waking up from the time of the Second World War and things are beginning to change around the world. But let me assure you that impossible things happen right here in Sri Lanka. This is the place that things really impossible happen. I don't think anywhere else in the world, for example, we've had two prime ministers at the same time. Nor, for example, have we had a situation in which a chief justice is sacked by parliament and then a few years later brought on the bench for a day. These are not things that generally happen. Or, for example, where judges are sacked overnight and new judges are appointed under a new constitution. This happened when the 78 constitution was enacted during the regime of J.R. Jayawardena. So you can see that a lot of impossible things happen. We were discussing in the room inside here how there is some controversy around the previous IGP and the new IGP. So impossible things are happening again. And this then leads to the fact that, for example, there was a time when judges were locked out of the courts, including the Supreme Court, and the army and the police were patrolling and excluded them. They had to meet in their homes, in the Chief Justice's home, to decide on cases. So as you can see, Sri Lanka is a place where impossible things happen, and therefore you can expect impossible things to happen with regard to human rights as well. So with that opening, I want to turn to some very important aspects concerning human rights. The first of these is the question of who is supreme in Sri Lanka. Very often I've heard, for example, the previous president, Mr. Ranil Wickremesinghe, very often claiming that Parliament is supreme. And I've heard other members of Parliament saying this as well. Parliament is supreme. And I can tell you, Parliament is not supreme under the law, nor is the Supreme Court and the judiciary, nor is the President. They are all three equal branches of government established under the Constitution. But what is really important is the Constitution itself tells us what is supreme in this country, and that is the Constitution itself. It says this is the supreme law, and the word supreme, other than in naming the Supreme Court, is used in the Constitution only once, and it is to describe the Constitution itself as the supreme law of the land. All of those things, such as Parliament, such as the judiciary, such as the executive, which derive their functions from the Constitution, are subsidiary organs, are institutions established by the supreme law. And therefore, it is not appropriate, or not correct, I would say, for anybody to claim that Parliament is supreme, or the judiciary is supreme, or the executive, the president is supreme. They're all equal branches of government providing checks and balances on each other. So keep that in mind as we discuss human rights, because this becomes very important as we discuss particularly the role of the judiciary, since we are going to be talking about litigation, but also alternate dispute resolution. The role of the judiciary becomes very important. Now, with regard to the role of the judiciary, I think it's important to note that we all generally recognize, and I think my colleague here mentioned it as well, that under the Constitution, the Supreme Court has been given sole and exclusive jurisdiction with regard to human rights violation through executive and administrative action. It's important to keep those words in mind, administrative and executive action. Now, while that is true, and while it is a very important institution, a very important forum in which we go to and apply for relief when individual human rights are violated, it is not the only institution concerned with the protection of human rights. And what I would like to do this evening is try to expand our perspective as professionals and look at some of these other institutions, other ways and other tools and other mechanisms that are available to us for the protection of human rights. Because then when we do that, you will understand that professionals, not just lawyers, all professionals can play a much bigger role in the protection of human rights. With regard to the functions of the judiciary, if you might look at the Supreme Court and the judiciary itself, there is a very special provision in the Constitution, which is Article 105. We don't refer to this provision very much, but in my mind, it is an extremely important provision. And what it says is that the judiciary, the institutions for the administration of justice, and I'm actually quoting from Article 105, are there to protect, vindicate, and enforce the rights of the people. The judiciary is there and established under Article 105 as the institution for the administration of justice, which protects, vindicates, and enforces the rights of the people. And then it says, shall be the Supreme Court, shall be the Court of Appeal, shall be the High Court, and so on. It then names all the different courts which constitute the judiciary. So, as judges, in my view, one of the foremost functions of a judge is exactly what the Constitution says: to uphold, to vindicate, to enforce, to defend the rights of the people. And as we look at history, we can identify several situations in which I feel the Supreme Court actually let the people down. And I say this not in any way to criticize the Supreme Court, but to draw attention to the fact that in the past, this provision of the Constitution has not really been given life to. One of these instances where this happened was when there was a referendum to extend the life of Parliament from the old Parliament had already spent its life, I think 5 or 6 years, and Mr. J.R. Jayawardena, who was then the president, decided he would have a referendum to extend the life of Parliament by 6 years. It was challenged in the Supreme Court, and there was a decision of 4 against 3 judges. 3 judges dissented, including, they didn't name who the 3 judges who dissented were, but it was reputed that the Chief Justice Neville Summers-Corn at that time, and 2 other judges joined the dissent. And the question really was whether there was a right to extend the right of Parliament, for that particular Parliament, which had been elected under a separate system of elections, to extend its life by a referendum. And 3 judges said they did not think that that was possible. And unfortunately, the life of that Parliament did get extended because there was a referendum and the people voted to extend the life of that Parliament. But that is a situation in which I felt that the Supreme Court actually took away the right of the people to choose their representatives, instead of, as Article 105 says, protecting, vindicating, and enforcing the rights of the people. The right to vote, the right to select your representative is such a fundamental right in a democracy. And I feel that that was a situation in which the Supreme Court, could have made a different decision which kind of gave life to this right, because it protects human rights. Another situation was, of course, more recently, when you had 2 prime ministers. Thankfully, the Supreme Court made the right decision and said, you can only have 1 prime minister at a time. So you can see that the court does play a very important role in the protection of human rights. I want to also now, at this point, look at another aspect of human rights protections, which is the power given to the Supreme Court where you can challenge bills that are coming up in Parliament. As you know, legislation is one of the ways in which human rights are eroded. I think my colleague here mentioned the PT, what is it called? The Prevention of Terrorism Act, the PTA, in which a minister can make an order for the arrest of somebody, and that person can be arrested and held in detention without access to the courts, other than perhaps by way of a habeas corpus application, for a long period of time, without trial. And this is a serious erosion of human rights. This has been mentioned many times, challenged many times, but that is the situation under the PTA. Now, one of the things that is important is that when a bill is presented in Parliament, when draft legislation is presented in Parliament, any citizen has the right to challenge it before the Supreme Court on the basis that it violates a provision of the Constitution. Now, that is the protection that the Constitution gives with regard to legislation. But we must keep in mind that before the 1972 and 78 Constitution, our Supreme Court had what is called post-legislative judicial review, the power of post-legislative judicial review, which is that the court could strike down a law even after it is passed by Parliament if it violates the Constitution. That seems to have been taken away in the 72 and 78 constitutions, and what you have today is pre-legislative judicial review, which simply means the Supreme Court can pronounce a bill unconstitutional, and then you might require a special majority in the Parliament, like a 2/3 majority, to pass that law, or you might say, in addition, you need a referendum. So there are some special provisions that come into effect if the Supreme Court says that this particular law violates the Constitution. Now, that was not the case before. Our courts enjoyed the right of judicial review. They could strike down laws. And this is a right that usually you still have, for example, in the US Supreme Court and in some other courts as well around the world. Now, I say, and again, this might be a little controversial from a legal standpoint, I say, notwithstanding this provision of pre-legislative judicial review, I believe the judiciary under our Constitution still retains the right of judicial review of legislation. And let me give you an illustration why I say that. There is Article 11, I believe, of the Constitution, which creates a freedom from torture and inhuman and degrading treatment. So that is a human right we all enjoy under the Constitution. So if any of us are tortured or dealt with in an inhumane way, then we can go to the Supreme Court and claim some relief against that violation, particularly if it is by a police officer or an executive or administrative officer of the government. But one of the important things about this article level freedom from torture provision is that it is absolute. There are no restrictions under the Constitution with regard to this right. Now let's assume that Parliament one day gets up and decides to enact a law which says that the minister, let's say the Minister of Defense, may by order published in the Gazette, order the detention of somebody and may order the whipping and waterboarding and a whole list of tortures that are listed, may do all of these things in order to extract the truth. Let's say this is the law that is to be passed. Now, obviously, somebody, any one of you, any one of us, can challenge the law in the Supreme Court, and it is very likely the Supreme Court will say that it violates Article 11 and therefore requires a two-thirds majority and a referendum. Okay? And so Parliament sits and says, yes, we are going to pass this now. They do have a two-thirds majority. They can say, we are going to pass this with a two-thirds majority. It will be passed with a two-thirds majority. It will be put to the people. There will be a lot of campaigning and a lot of advertising on TV, on billboards saying this is a wonderful law, and the people will, let's say at a referendum, adopt this new law. Let's say the law is adopted. So we now have a law which the Supreme Court has declared to be contrary to the Constitution and to fundamental rights. It has now been adopted in keeping with the Constitution and has become law. An order is made by the minister under the law for the torture of Mr. Lalanath De Silva, for example. As an example. And Mr. Madhigada then has one of two choices. Either he allows this to happen, which I don't think he will, but we'll all rally around him, and we will then make an application to the Supreme Court for the violation of his human right and his freedom from torture and inhuman treatment. Now the court is faced with a dilemma. And the dilemma is this. There is a validly passed constitutional law which authorizes the minister to do what he is doing. At the same time, you have a constitutional provision which guarantees the fundamental rights of Mr. Madhigada. Which of these two will it uphold? That's the question for the judges. Which of these two will it uphold? In my view, having taken an oath to uphold the Constitution, having been named in the Constitution by Article 105 as the institution to vindicate and protect and enforce the rights of the people, I don't think a judge has a choice but to uphold the constitutional provision. And to say Mr. Madhigada cannot be tortured, he must be released. What in effect the court is doing is to declare that law unconstitutional. It is a kind of judicial review, even though there is a provision in the Constitution which says no court shall challenge that law, etc., etc. In my view, when Parliament passes laws that are clearly violative of the fundamental rights chapter, it is setting itself up with the court for a potential declaration post-legislation, after the legislation is passed, that the law is invalid, or not, may not be invalid, but just unenforceable as against the Constitution, which is practically saying that it is of no force or effect. So this is an important point I want to make. This might be a little bit controversial from a legal standpoint, but I think those are the kinds of things that we should be testing when it comes to looking at the judiciary and the ways in which we can bring to bear the constitutional provisions. Another very important provision, an idea that I want to float here, is that the constitutional provisions, some of the constitutional provisions with regard to fundamental rights, are not necessarily applicable to the state alone. For example, let me give you an example what I mean by this. If you take Article 12.3, it says that no person shall be discriminated on the basis of race, religion, color, etc., etc., with regard to the admission to a hotel, restaurant, and so on and so forth. Now we know that if you go down south, there are many places in the hotels which say foreigners only. You've seen that, it's been in the press. Recently there was something on TikTok where two young people went to a little hotel and they refused to serve them kottu roti because that was only meant for the tourists. This was a TikTok going around. So this is happening in our country. It is a clear violation of Article 12.3 of the Constitution. But it is not an administrative or executive act in which you can go to the Supreme Court. Where can you go for relief? There's the old Roman saying, I buy jus, you buy remedium, which is if there is a right, there must be a remedy. So where is the remedy for this? I would say perhaps in the district court by way of a declaration, but these are things that will take a long time. But maybe the court would have to refer it back to the Supreme Court. So there are provisions in the fundamental rights, human rights chapter of our Constitution, which are not necessarily directed at the state, but are actually directed at private corporations, companies, and individuals. And there must be a way in which we can hold those individuals accountable when they violate those rights. So here again is another interesting area which can be explored not only by lawyers but also by you as professionals. You know, you might be amongst you professionals who are involved in advising hotels and advising the government, and it is important to keep those kinds of provisions in mind. And then the last thing I want to really touch on, with this evening is to raise the question with regard to public interest litigation. There's a lot of public interest litigation that has taken place over the last few years. And we have followed the example of India and Bangladesh and Pakistan, where similar litigation is taking place. I think there's a huge role for professionals in public interest litigation. When a professional goes to court and says something has happened, a judge is much more willing to listen to them than, for example, a citizen. And it's not that they're discriminating against normal citizens, it's simply that there is generally a lot of respect for an architect or for an accountant or for any of these other professionals who are part of your association. So I think there's an important role for professionals. And one of the places that you can go to, of course, is the Court of Appeal, where you can apply by way of a writ application or what is called judicial review for forcing a government officer to do their job. Or it could be that you're challenging a decision that a government officer has made. I can give you some examples. We don't need to go far. And these are examples that are all around us where I think professionals can take action. Just the other day, I went to Sigiriya. I went to Sigiriya with two Korean friends from the Green Climate Fund. And when I went there, there is an entrance which is very far from the Sigiriya rock, where locals, citizens, have to go and buy their tickets, and they have to walk all the way through the pleasure gardens in order to climb the rock. But if you're a foreigner, you can drive right next to the rock, get off there, and you can climb the rock. So I went through that entrance. I was stopped. I said, well, your two friends can go from Korea, but you can't go because you're Asian. Now this is discriminatory. This is an issue that any one of you can take up. And you don't even have to go to court. You should be writing to the Central Cultural Fund and saying this is discriminatory, it's against the Constitution, this is a violation of the Equality Clause. I am a Sri Lankan citizen. There is no reason why you should not be issuing tickets at both ends. Or having the tourists also do the same route as everybody else. And therefore, that you are prepared to challenge this if they don't change the law. Now, I can tell you that about 10 years ago when this incident happened, the same thing has happened before, by the way. I did write to the Central Cultural Triangle, and the Commissioner of Archaeology responded saying, we're very sorry, Mr. De Silva, this was a mistake, not by us, but he put the blame entirely on the poor officers out there in Sigiriya, saying that they have misunderstood the whole situation and that they were going to correct it. Now, whether they corrected it or not, I do not know, but I know 10 years later, the same thing is happening still, right? So there is a problem that the state never learns from correction, and this has to be repeated over and over again. So these are just some examples of where I think, this is just a simple example of where I think you can take some action. Just this afternoon before I came here, there was a little incident I can recite. Again, public interest litigation, and this may not necessarily relate to a human right, though I think it does relate to the right to health, for example, which is not necessarily a guaranteed human right, but certainly recognized in international instruments. I live in the Kaduwala Pradeshiya Sabha area in Palavatta. They're supposed to collect our garbage on Wednesday. So we put out our garbage, no truck. So I took the garbage back. So normally when they don't come on a Wednesday, they come on the next day. So I put the garbage out on Thursday morning. There's no truck on Thursday morning either. By this time, by the way, the garbage is now putrefying and smelling, and it's a tropical country, so you can imagine what is going on in there. So this morning, on Friday morning, I called the Municipal Council's waste unit and I said, what's going on? And they said, oh, we are very, very sorry. We are going to send you a truck today. So I said, okay, do you want me to put the garbage out? They said, yes, put it out. So I put it out. 11 o'clock came and there is no garbage truck. So I called them again and said, no, don't worry, we are sending the truck. And 3:30 came, there's still no truck. So I called them and then they say, very sorry, sir. The man nearly came to your house, but he fell ill, and we had to send him to hospital. So this is the excuse. Rich dialogue as the evening proceeds. Thank you very much.
Thank you, Dr. De Silva, bringing away that insightful legal dimensions on our subject, which is protection of individual human rights. Turning to our next speaker, is a well-known legal academic and practitioner, known for his work in litigation and dispute resolution. Please join me in welcoming Dr. Asanga Gunawansa, President's Counsel, who will speak on the role of litigation and alternate dispute resolution.
Good evening to everyone. I would like to thank the OPA as well as the Bar Association for inviting me today. I have to be very well disciplined today for two reasons. I'll start with that. And there was only once that I got caught to a prefect and got detention, and that was unfortunately when I was in year 6 to Dr. Lalanath De Silva. So much so years later we became good friends, and when my late wife used to get angry with me, she always told me, I'm going to tell Lalanath. And then years later when I joined the AG's department, I had a favorite aunt who was also very fond of Mr. Lalanath De Silva. Probably had told him that I was a troublemaker. He was the State Council Administration, and he said, you better not misbehave and get caught. So if I behave very well, thanks to these two gentlemen today. Now, I was going to talk to you about alternative dispute resolution and how it is relevant to the rule of law. So I'm not going to go deep into arbitration and various ADR mechanisms as a subject because I have to connect it to the concept of rule of law. But I think I'm going to pick up from certain comments that Lalanath made, not to disagree with him, but let's look at it this way. Lalanath, what he said is absolutely right. There are two places or two instances in which our constitution uses the word supreme, and one is to say that the supreme law is the constitution. And he said there are three bodies, the legislative body, the executive body, and the judiciary. All are equally powerful, and therefore there can't be an upper guardian of the constitution. But is that really correct? Think about it. I'm not disagreeing with them. Since he also mentioned about the US, let's look at the US. The US Constitution was written in 1787, or signed in 1787 after 17 months of negotiations by the lawmakers. 237 years later, it has had, if I'm not mistaken, Lalanath can correct me, 27 amendments in 237 years. We have a constitution which is less than 78 years old, and so far we have 22 amendments. The way to go, right? And if the constitution can be amended so easily, according to the whims and fancies, whoever gets into parliament and goes unchallenged, one would wonder, is that the reason as to why our parliamentarians think parliament is supreme? Now, can we put a stop to it? And I think yes. The upper guardian of the constitution is not these three institutions, it's we the people. Right? And I don't think we should forget that. And it's we who put our elected members into parliament. And every time we blame the government saying that they are making mistakes or they are horrible, they are corrupt and so on, we have to look in the mirror and blame ourselves. If we had done the right thing, perhaps we could have prevented all that. Now getting back to the topic about rule of law, what is rule of law? The rule of law, as defined, is a fundamental principle asserting that everyone, including those in power, right, including those in power, is subject to and accountable under the law, ensuring fairness, transparency, and protection of the rights. That is rule of law. Now, rule of law is required in any legal regime, in any jurisdiction, not only to protect fundamental rights, but also to regulate the conduct of officers, executives who are in government, the private sector, and we the people who have rights, and we the people who enter into commercial and trade transactions and so on. Everything gets regulated because there's a system of law, and if the system of law is to properly function, there has to be a rule. There has to be a rule of law, and to have rule of law, there has to be law. Then the question is, what is law? Let's take Sri Lanka, for example. Now, we have what I call a fruit salad legal system. Right? Why do I say we have a fruit salad legal system? If you go to England and ask somebody, what is your common law, what is your law, they say, we are a common law country. English common law is the law that is practiced. What is the common law of Sri Lanka? We say we do practice English law in an area that has been specifically introduced. Our common law is Roman Dutch law. And the Roman Dutch law we practice here is something that was introduced by the Dutch colonial powers, 500 or 600 years ago, not practiced anywhere else in the world, perhaps except to some extent in South Africa. Then we have our indigenous laws, right? We have the Tesavalami law, the Kandyan law, the Mukwa law, the Muslim laws and all that. And we have statutory laws, laws passed by Parliament. Now, I'm going to focus on these statutory laws. Starting from the Constitution itself, our laws are flawed. One of the reasons as to why the Constitution has to be amended 22 times, some may be due to political whims and fancies of those in power, but there are other reasons because there were fundamental errors. Have we fixed all the problems? To date, no. I simply invite you to go and look at the chapter 3 of the Constitution, which deals with fundamental rights. It refers to, presumably, 3 different types of persons. Natural persons, legal persons, and citizens. Article 16 of the Constitution defines what a citizen is. But then when you look at Article 10, 11, 12, 13, 14, sometimes it refers to rights of a citizen, sometimes it refers to rights of a person, right? And it is not clear whether this person is just to refer to a legal or natural person. And as a result of that, there have been instances where corporate entities come before the Supreme Court and say that their fundamental rights have been violated, especially in connection with procurement contracts and so on. And some years ago, I remember, if I'm not mistaken, in the Goldface Green case, Mr. Faiz Mustafa, President's Counsel, tried to argue this point. And then Justice Sarah Silva made a passing remark, I don't think it's binding authority, although subsequent judgments have believed it to be binding. In my view, any side view expressed by a judge is just obiter dicta and it's not binding. But he did say that, even corporate entities can come. I also think they can come, but in certain instances. But it had not been provided, there is no clarity provided to it. Why I say there is no clarity is, and because at the end of the day, in order to interpret a law, you have to look at the intention of the lawmaker. And the intention of the lawmaker is very clear because the chapter 3 of the Constitution, which deals with fundamental rights, after the 1978 Constitution came into play, has been amended only once. That is by bringing Article 14A, which deals with the right to information provisions. Now, in Article 4A2, if one reads, it very specifically says, it talks about right to information that a citizen has. Then 14A says, for the purposes of this article, citizen includes any association or corporation of which more than 75% of the members are citizens. So then it's very clear where the lawmakers had the intention of applying something beyond a citizen, they have clarified in the Constitution. Right. Now, say for example, right to join a trade union, right? Right to form a trade union or join a trade union. Right to have employment. Now we all say US has one of the leading democracies, very good constitution. Can I go to the US and assert a fundamental right to be employed? Can I? No, I'm a foreigner, I can't. But if I'm arbitrarily arrested, right, then can I say that my fundamental rights have been violated? Yes, I can. So there are differences in these, which have not been, properly understood. There's a reason for that. Why I say our lawmaking process before we talk about rule of law is flawed is for this reason. According to our constitution, we have 3 official languages: English, Sinhalese, and Tamil. All the laws and regulations, subsidiary legislation that is introduced, passed, are published in all 3 languages. The constitution itself says, in the event of any contradiction between any of the versions, Sinhala version prevails. Does anyone here know any law that was originally drafted in Sinhalese? I counted the other day in my 30-year career, Dr. Lalanath would have done many more, and I'm sure Amra would have done many more. I have been involved in drafting 21 laws, different types of laws. Not a single one of these laws were originally drafted in Sinhalese. All were drafted in English. Then, when they are sent for translation, sometimes the legal draftsman doesn't even have proper translators. So by the time the translations come 6 months later, the original committee who was put together to draft, they have gone on to do other things, they have no time to read. Right? Then a Sinhala version comes, that becomes the prevailing version. Right? Which is why when we now look at the English version, sometimes it makes sense. You look at the Sinhala version, it says something else, completely different. And do these things get the attention of the court? No. Every time an act is introduced, as a bill in Parliament or there's an amendment to the Constitution, not every bill is challenged before the Supreme Court. Not every amendment to the Constitution is challenged. Even when it is challenged, not every section, every provision that is challenged. The people who are involved in public interest litigation may focus on certain areas and say that, okay, amend these. And then the Supreme Court may look at it and say that yes, certain. So there are several sections that go unnoticed. So unless we fix this problem going forward, we are going to have a continuing issue with regard to our law itself. And if our law is bad, we will certainly have issues with regard to rule of law, implementation, everything that flows from that, right? That is something that we need to deal with. Now coming back to using alternative dispute resolution mechanisms for the purpose of implementing rule of law, what we need to first understand is what is ADR, what is alternative dispute resolution mechanism, including arbitration. Now, in any country, any legal system, there is a hierarchy of courts. The court system is created by the existing laws and it is provided for. So for example, when I leave this place today, if somebody comes and attacks me physically, or somebody steals from me, or I have entered into a contract, somebody breaches that contract, to go to the court system that is provided in any country, including Sri Lanka, I don't need anybody's permission. It's a system of courts that has been provided to implement rule of law. And if I have a grievance, I make a complaint to the police. And if it is a private dispute, I go to the appropriate court of jurisdiction and I go and file legal action. The counterparty to my grievance, I don't need his permission. Right? That is because the system of courts is provided by the system of law. But if I deviate from that, walk away from that, and say that I don't want to go to court, I don't believe in court, that delays, my solution, and that's I will incur unnecessary cost. I want private dispute resolution, which is alternative dispute resolution mechanism. Can I force someone else to go for private dispute resolution? No, I can't. I can only do it if the other party agrees, right? So the fundamental basis of the very existence of alternative dispute resolution is party autonomy, which allows the parties to agree that a dispute can be taken out of the court system and submitted to alternative dispute resolution mechanism agreed between the parties to resolve that, right? Now, having said that, the next question that we have to think about answer is, can every type of dispute be resolved through alternative dispute resolution? We can't. If I commit a murder today, or if I commit a theft or any other criminal offense, can I have an agreement with the victim or victim's family or survivors and say that let's go to ADR and resolve this? No. Because the moment you commit a crime, that crime is considered a crime committed not only against the victim, against the entire civil society, which is why the prosecutory powers are taken by the police and the Attorney General, and the system prosecutes you, right? So you can't cut a deal and go to arbitration or mediation and negotiation and get out of punishment when you commit a crime. But you can still use ADR. I'll come to that in a minute, to some extent. Let's assume that you want to annul a marriage. Can you go to private dispute resolution and, get a dissolution of the marriage that is legally valid? No. You have to go to court. If you want to adopt a child today, can you have a private agreement and say that I'm adopting your child? That's not legal. That has to be recognized by court. However, the negotiation part of it, even in a divorce, to make it less controversial, and less confrontational, you can have negotiations, you can have mediations, you can come to an understanding, but you still need to take it before a court of law and get a decree from court for it to be valid, right? So even in disputes, private disputes, which are not arbitrable or which cannot be submitted to ADR for a final resolution, like divorce, adoption of a child, just 2 examples, we can still use alternative dispute resolution mechanisms to find a solution. But the final solution has to come through a court of law. Now, in the case of murder and criminal activities, the popular belief is that no, ADR plays no role. But I say it has a role. How do an offender turn into be a state witness? How do an offender turn into be a state witness and go with a lenient punishment because he helps the state? Through negotiations, because they have come to an understanding, right? So even in criminal offences, there's a role for ADR to play. You might not be able to get out of it, but you might be able to mitigate, right, what you're going to face as a consequence. However, when it comes to commercial and trade and contractual transactions, that's a different ballgame altogether. Because all those are private contractual transactions, commercial transactions between parties. You can enter into alternative dispute resolution mechanisms using the party autonomy and agree to resolve that dispute outside of court. However, the rule of law again comes into play. There are certain principles within which you have to work. I'll give you a simple example. Now, if you go to, these days we can go visa-free to Thailand. If anybody goes, you will see in every corner there is a ganja kadi. I say ganja kadi. The shops where they sell cannabis. Every corner you get, these. If you go to, United States, Netherlands, in some parts, some provinces, some states, in the US, it's legal to trade in cannabis. It's not illegal conduct. Now assume that I go to US, right? I tell somebody, I am, in Tanamalula in Sri Lanka, we produce the best cannabis, and I will supply, right, 500 tons, provided you pay me $50,000, but I need $10,000 upfront, right? And we sign a nice agreement. We say that, okay, this dispute shall be resolved by arbitration. So party autonomy is used. Arbitration is the way of resolving the dispute. We say the seat of arbitration will be New York, all that I have agreed. I take the $10,000 and come to Sri Lanka, and I can't export cannabis. So I breach the contract. I say, okay, let the fellow go to hell. I have got my money. I am sitting happy here. But it's a legal contract there. So what will they do? They will probably, file an for arbitration in an arbitration center in New York, send me notices, I don't go. There will be ex parte hearing, and an award will be given in favor of the party in the US. Now that award is not worth the paper is written on, because I have no assets in the US. I'm in Sri Lanka. So they have to come and enforce it in Sri Lanka, right? Now when they come to enforce it in Sri Lanka, what happens? So there is this convention called the New York Convention of 1958, right? To which there are approximately 200 countries in the world. About 180 countries today are signatories to the New York Convention, including Sri Lanka. It's called, the real name is the Convention on Enforcement of Foreign Arbitral Awards, right? So by being a signatory, you say that any arbitration award given in any other member country can be enforced through the courts in any other country. However, there are certain constraints. One is the award cannot be against the public policy of the country in which you seek enforcement. The other one is the contract cannot be illegal in the country in which you try to enforce it. So now when they try to enforce the decree in Sri Lanka, can they enforce it here? No. One is it's against public policy to recognize the contract, for sale of cannabis. Other one is it's illegal trade in Sri Lanka, right? So even though you can use alternative dispute resolution mechanisms to resolve private disputes in an international context, even in a legal domestic context, it has to be a legally valid contract. Now we know there are a lot of contract killings happening these days, right? Imagine a contract killer, we know there's a promise. Contract can be made, it doesn't have to be in writing. Contract can be made by word, by conduct, right? And so there is a verbal understanding, A kills B and C has promised to pay A, 10 million rupees or whatever. And then they have also said, okay, if you have a dispute, we go for mediation or arbitration or whatever, right? So now the killing happens, the killer goes and asks for the money and money is not paid. Can he go for arbitration or mediation and cut a deal and get the money? No. Illegal. So it has to be legal. So as long as it's legal, you can use alternative dispute resolution mechanisms. Now having said that, the alternative dispute resolution mechanisms, if it's to work, it has to have certain features, right? One is people should have access to it. Then it should be a forum in which there is equal protection provided to people who participate in resolving disputes through these kind of mechanisms. It has to be fair, it has to be transparent, it has to be affordable, time and cost efficient, and also the decisions have to be enforceable, right? Now in all there are several ADR mechanisms in the world that are being used. One is negotiation, conciliation, mediation, expert decision making, adjudication, used a lot in the construction industry, and finally arbitration. Out of these 6 methods, the universally accepted, the most popular mechanism has become arbitration. And for that there are 2 reasons. Reason number 1 I already told you, right? That is the New York Convention of 1958, which enables enforcement of arbitration award made in one country in another country. Other one is in the mid-1980s, the United Nations Convention on International Trade Law. They came up with a model law on arbitration called the UNCITRAL model law. The whole idea was to develop a body of law that can be almost identical in every country that practices arbitration. So UNCITRAL model law has been, or rather today about 140 countries in the world have adopted UNCITRAL model law, and they have laws which are almost a mirror image of the UNCITRAL model law. And this has helped the development of jurisprudence on arbitration, which is almost identical in most countries, right? It's almost identical in most countries. But having said that, I'm going back to, with this I'm going to stop. After that we can start a Q&A. I go back to my issue, we can have all this, but if we do not fix the way we draft the laws, right, we are going to have a problem. Now, UNCITRAL model law, right, has this interesting provision. In international, in arbitration, whether it's international or domestic, we have a concept called competence. It's a German word. It means if there is a jurisdictional challenge made with regard to the arbitrator's right to hear a case, the arbitrator themselves have the right to decide, right? That is what the competence principle means, right? In every arbitration statute in the world, be it England, America, Australia, New Zealand, Singapore, India, you can check, the principle is there. Then in all these other statutes that I said, including the UNCITRAL model law, it says that if you have a jurisdictional problem with the arbitrator, you raise it with the arbitrator first. If you are not happy with the arbitrator decision, within 60 days or within 90 days or whatever, there's a designated court, you can go to the court and make an appeal, right? Sri Lankan Arbitration Act. What happened? We say, we recognize the principle of competence. You can make the jurisdictional objection before the tribunal, but you can also go to court. Not after, but you can also go to court. This has resulted in parallel applications being made both before the arbitrator and the court, right? And we also have situations in which arbitrator says, I have jurisdiction, court says you don't have. Some situations arbitrator says I don't have, court says no, you have jurisdiction, right? Now there are several matters pending before the Supreme Court to fix it. Why? A fundamental error in drafting laws, right? So it's very good for us to talk about the rule of law. And just in order to summarize, as I said, arbitration and alternative dispute resolution mechanism does have a role to play, right, in establishing and implementing and enforcing the rule of law. But in order to do that, we have to have a proper legal system that caters to that. In Sri Lanka, some of the problems that we have had with regard to laws delays is because our laws are very poorly drafted and very poorly enforced. Now, one of the biggest advantages, I'm sure there are a lot of engineers here, they would know they are definitely involved in, commercial and contractual and construction disputes here. The whole idea of arbitration was to fast track dispute resolution, right? Because if you go to court in Sri Lanka, even in the best case scenario, if you go to the commercial high court, a minimum 5 years will take for you to resolve a dispute there, get a decision. But if somebody appeals from there, then it's 15 years, right? So we were, the expectation was you go to arbitration within 2 to 3 months, you can get a decision. But unfortunately, that is not the case. That is because of the culture we have. We have Gedara Gamang arbitration. The reason is, if you go to Singapore, if you go to UK, if you go to England or any of these countries, the arbitrators sit at 9 in the morning, go until 6 in the evening. By 8 p.m. you will have the transcripts of the proceeding. You can have 5 consecutive days of hearing. Over the weekend, the award will be written. By following Monday, the award will be out, right? In the worst case scenario, it will take about a month. You get a decision. In Sri Lanka, we go to arbitration hearing. The retired judges come as the arbitrators. Same lawyers in Halstor finish all their work, have an afternoon nap, come at 4:30. That's why I say Gedara Gamang. By 6 o'clock, the arbitration is over. They go. The next day, it is 3 months from now. And still, just like the court cases, it will get dragged on and on and on. Right? So we have to, if we are true to, if our expectation is to have a proper rule of law and implement it properly, A, we have to fix the way we pass the laws and interpret them. B, we have to fix the way we implement them. C, culturally, as a, legal practitioners, and everybody else, the other stakeholders, we need to change. So I'll stop there. I'll be happy to respond to any questions if you have. Thank you very much.
Thank you very much, Dr. Asanga Gunawansa, for bringing a wealth of wisdom for the subject of litigation and alternative dispute resolution. And now, to bring all our discussions together in an interactive format, we move into the next part of the evening, the moderator session. It is my pleasure to once again invite Mr. Anura Medegoda, President's Counsel, President of the Bar Association of Sri Lanka, to take over as the moderator for this session. Over to you, sir.
Well, ladies and gentlemen, let me first thank both interesting presentations that they made this evening. Dr. Lalanath did speak, certainly in his speech, he raised a hornet's nest about the post-enactment judicial review. Whether in Sri Lanka, and it is expressed his view that in Sri Lanka, despite what is said in the constitution, that the law still recognizes judicial review post-enactment, as was recognized in the Salisbury Constitution 1947. Now that certainly, I'm sure the judges of this country, whatever they may have to say, certainly there will be strong disagreement among some of the judges of this country about the statement that was made by Dr. Lalanath. But still, I'm sure there will certainly be. But still, that requires debate in this country. Then on the Asanga did raise issues of ADR, methods of ADR and mediation, also in the adjudication of fundamental rights and freedoms in the rule of law. Now again there, and Asanga also did mention about the deep-rooted issues we have with regard to arbitration in this country. As was rightly said, it was what we have today is Gedara Yanagamang arbitration, which is what we all know, and certainly we also know, I'm sure Dr. Asanga will agree with me, that arbitrations will take the same length of time as litigation in Athens. So it is where people are very fast losing their faith and confidence in the systems of rule of law that we have. So these are all deep-rooted issues that we have to deal with, deep-rooted issues in our fabric of society, and we, the people, who are supreme under our constitution, it is for us to decide and also to make sure that our rulers of our country, the parliamentarians who enact laws, will make sure that they address all those issues that the people face. So those are the issues before us. And ladies and gentlemen, now I believe we have a few more minutes. May I open this discussion to the audience, and let us, have the views of our eminent speakers on this. Yes, there is a lot of interest. Can you introduce yourself, please?
I'm Dilhan Tutia again, economist from Sri Lanka Economic Association.
Thank you very much, Dilhan.
And my question I think must be most relevant to Dr.
Lalanath De
Silva. Recently there is a talk of economic human rights. I think economic human rights is something new, at least to my ears. I mean, after the Sri Lankan economy went down, certain people in Sri Lanka got accused of violating economic human rights. So can you elaborate to us and tell us what is economic human rights in an international context? And in Sri Lanka, in theory, I mean, what sort of legal framework or legal anything we have regarding to address economic human rights?
Thank you. Any other questions? Shall we take a few questions and then thereafter we'll address them to let the speakers address them. Yes,
I am Kamal, President of the Sri Lanka Institute of Service Management.
Thank you.
Now Mr. Lalanath, he mentioned about some cases, Chigiri and another restaurant where somebody went to the restaurant and ordered some authorities, we don't important sort this out. Though it looked so simple, I mean, if that person has to go to Supreme Court on this issue, he may have to spend a few years and spend more than 1,000 authorities cost to pay for the case. So those things are not really practical. I do not think that this kind of thing can be, accepted in practice. Can you kindly give your
elaborate
response?
Thank you. There's a third question. Yes, Dr. Ratnavir. Mr. Ratnavir. Senior attorney. Yes.
I must first thank both the OPA and the BSL who have given this opportunity for this entertaining and at the same time thought-provoking sessions that both speakers provided. First of all, Dr. Lalanath De Silva mentioned post-legislative review, which I think is a crying need for our country, because as Dr. Gunawansa also mentioned that there are flaws, fundamental flaws in the drafting of the constitution and other laws. So what is the way to bring back this post-legislative review? Because as Mr. Medagura stated, it had been there until the Salisbury Constitution. Only the 1972 and the 1978 constitutions eliminated that facility, that provision.
It was there until the 72 Constitution.
That's right.
Yes, and then 72 Constitution expressly took away the right to post-enactment judicial review, and thereafter the 78 Constitution
1978 one.
as well, yes.
So what is the way to bring back this, at least, to make our legislators, our MPs, to be aware, to bring back this provision so that the people's rights could be protected, because we find that there are oppressive sort of provisions For example, in the State Lands Recovery Opposition Act, we have this ridiculous sort of position where the competent authority is given the power. Whenever he thinks, he is of the opinion that it's a state land, he could declare that it's a state land and then tell the occupant to get away from that. And it cannot be challenged in the court. So these are arbitrary provisions which have found their way into our laws. And one way of challenging that is by way of bringing back the post-legislative review. So that's the crying need. That's what I, if Dr. Lalanath De Silva could explain that further.
You'll also, yes, you'll also address that issue to both Dr.
Yes,
Gunawansa and Dr. Lalanath. Thank you.
Now, recently, there is a law which has been already enacted stating that when it comes to capital gain tax, the investment property can be valued by a tax officer. So how come a tax officer be qualified to value a property? There are valuers. So then what is their role? So those things have come into effect into the law, right, which we think which is not suitable. So we are also helpless sometimes, even though the what you call.
Thank you for all those questions. I think they are all very important and also shows that there's a real diversity of professionals here with different issues to raise. So I'll try and go down the list. I'm not sure I'll be able to answer all of the questions, but I'll do my best. So I think the first question, which was from Dilhan, I hope I got your name correctly, was about economic human rights. I think the best answer I can give is that if you go back in the history of human rights, you start, let's say, in the 1940s with the Declaration of Human Rights, the UN Declaration of Human Rights, which codified what was at that point post Second World War, the understanding of human rights at that time. So we're talking almost 75, 80 years ago. And those were rights mostly which are called the core human rights. So you have the right to a fair trial. You have the right to be brought before a judge after arrest, or due process of law, the freedom of speech, the freedom of thought and conscience. These are what are called the core rights. And then a few years later, you had what was called the protocols on economic rights, the social economics and rights, and the other one was on political and civil and political rights. The two protocols, which kind of enlarged on the core rights. So they kind of enlarged on those rights and specified certain other rights which were important in order for those core rights to be properly enjoyed. And for many years, those were what was considered kind of the important human rights. Until I think the 1970s and the 80s, with the rise of the environmental movement, there was what are called the third generation rights, which is the rights where you're talking about environmental rights. So for example, the right to life, which was one of the core rights in the Universal Declaration, was taken and interpreted as including the right to a healthy environment. You can't live life unless you have a healthy environment to live it in. So those were the third generation rights. And economic rights, I believe falls into that category, where you're taking the core rights and enlarging it. So the right to life must surely also mean the right to a livelihood. What is the point of living if you can't make ends meet, if you can't earn a living? If you can't earn adequately in order to, supply your food and supply a roof above your head and clothing. So those rights, the right to water, these were things which are treated as third generation rights. So economic human rights are in that category. And they are, I think, an expansion, an extension, if you like, of these original core rights. So the right to livelihood would be an example of an economic right that I could think of. So I'm not sure I fully answered your question, but that's the direction in which I think we need to think. Mr. Karunaratna was talking about kottu roti issue. I'm not advocating that when you go to a restaurant, if you are denied your kottu roti, that you should rush to court. No, I'm not saying that, because that's expensive. and it's going to cost you a lot of money. But what I am saying is that it is that you have a human right which is in the Constitution. You should be able to go to any restaurant, any public place, any hotel, and be treated equally with everybody else. Whatever your color, whatever your race, whatever your religious beliefs, you should not be treated differently. So what can you do if you face this situation? That's the question, right? What could these young people who face the Kothurati, they decided to go public. They put it on TikTok, and now everyone is talking about it. I think people are probably boycotting that place, and people are not going to there, and they got a lot of bad reputation. So going public, talking about it, and raising awareness is one of the best solutions that you can have to a small issue, but an important issue which violates your human rights. Go public, talk to the press, and you have the social media now. You can put it on your Facebook, and let people know what is happening. They even had a photograph of the name board of that particular place, and so people were saying, a lot of comments, boycott this place, don't go to this place, and so on and so forth. But more than that, you can also challenge the shop owner. If you are aware, what you are doing by denying me this Kothurati is you are violating the Constitution. You are violating my human rights under the Constitution. If you are aware of that, you can say. So there's a huge need to raise the awareness of our public as professionals of our rights. Our rights education, public rights education is very weak actually. People don't know, for example, that a police officer can only keep you in a police station for 24 hours. Many people don't know even that. And the more we can educate the public, the more we can popularize the idea of legal literacy, the better for the country from the rule of law perspective. And then you can also complain to the police, you can write to the local authority and complain, because they are the ones who are giving a license for these people to run the shop or the hotel. You can also complain to the tourist board. By the way, the tourist board has a policy that says that you cannot discriminate. It's very clear. You can go on their website, it says so. So these are some of the things you can do. You don't have to rush to court. But if you really want to challenge it and make an issue out of it, I think it's a worthwhile case. Mr. Ratnavale, post-legislative judicial review, and you said, what can we do to bring it back? I think the main thing is public demand. We just have to build public demand for post-legislative judicial review. But I also think that it takes only bold judges to be able to carve that out for the court, which is what happened in a very famous US case, Marbury versus Madison, many years ago. The Chief Justice of the time decided that when you have a written constitution, unlike in England, by the way, which is supposed to have an unwritten constitution, that's also not partial, that's probably not true anymore. But there was a time that we all were taught as lawyers, England has an unwritten constitution, right? But the opposite of that is we all have written constitutions. The moment you write your constitution and declare it to be the supreme law, then everything else becomes subject to that law. And when it is subject to that law, there must be some authority in order to uphold that supremacy, to be able to declare things that are contrary to it are unconstitutional. It is obvious. I mean, it's a logical conclusion, which is the basis on which Marbury versus Madison decided. It therefore only takes a bold judge to write, and have other judges agree, of course, to write a judgment and claim it for the court. Now, that might create a political, crisis, but that is one way to do it. Whether we have those judges, I don't know, but that is one way to do it. The other one, of course, is to have educated legislators who, when I understand there might be a revision of the Constitution, can introduce it as part of our Constitution. But for that, there will have to be, I think, public demand, And Mr. Rohana Bandara Herath, your question is a very important one on the code of conduct. I think when you assert the code of conduct, if you hear arguments that what you're asking, let's say there's a violation of the code of conduct, and they say, yes, but I have a human right, I have a right to residence, or I have a right to practice my profession, I can do this, then I think there may be two issues here. One is, have you examined your code of conduct against human rights and seen whether there are contradictions? Because if there are contradictions, then you must consider amending and bringing your code of conduct in line with the recognized human rights. So that, I don't know whether that has been done, but that is one thing that has to be done. Secondly, of course, is the question is whether that argument that is being made is a valid argument, because it may not be a valid argument. It may be a red herring, and in many cases people may just throw these ideas out in the hope that something will strike through, but it may not be a valid idea. So I think it's important to examine both of those possibilities. And then the last question from Mr. Ranil Abhiratna on tax officers valuing properties. I think that's, not every tax officer will have the knowledge to be a valuer. But I think you're raising a much more fundamental question, which is our legislative process. We do not have adequate transparency, and we do not have adequate participation, public participation, in our legislative processes. And that is the fundamental problem that I see in how laws are made. We go to the polls once in 5 or 6 years and we vote, and we think that is our civic duty. It's done, finished. But between the 5 years, what happens? The public is not included in lawmaking. And I think that is a really big problem. We need to have, when a law is being published, it is not sufficient for just to be gazetted a couple of weeks before it's placed before Parliament or after it is read the first time in Parliament. You need to have public discussions of it. It needs to be published earlier. There needs to be public discussions. People who are affected by these new laws should have a right to say what they have to say. There should be public hearings. These have begun to happen, for example, in the environmental field, but it is not happening across the board. We do not have enough public participation in our lawmaking, whether they be at the local authorities, which are passing ordinances, or at the provincial council, which are passing statutes, or in Parliament, where the laws are being passed. There need to be more transparency, and there needs to be more participation. If that happens, then people like you can go and say, don't make the tax officer do this because they don't have the competence. And maybe that will be taken into account, and maybe there'll be a way to challenge it. So I see that as one of the biggest problems to solve with regard to, the problem that you identified.
With regard to the different fields, with regard to the implementation of the individual human rights in the context of the rule of law, from a litigation perspective, as was articulated by Dr. Lalanath De Silva, and from an ADR perspective, as demonstrated, as articulated by Dr. Asanga Gunawansa. So thank you very much. Thank you very much, ladies and gentlemen, for your presence, and thank you very much to the two eminent speakers for giving us of their expertise and their experiences this evening. Thank you.
Thank you very much, sir, for conducting the moderating the session, interactive session, which was really valuable. And now all must be, all the good things must be come to an end. So before that, let me invite you to for the ceremony of token of appreciation. Let me invite President of the OPA, Mr. Sujiwalal Dahanayaka, President-elect of the OPA, Mr. Jayanta Galheva, and the General Secretary of the OPA, Mr. Tisara De Silva, to the front. And also Bar Association, from the Bar Association, Mr. Lalanath De Silva, President's Council, for the stage. I think first, let us greet with the token of appreciation Dr. Lalanath De Silva. Please come forward. As the gentlemen are taking the seats, let me invite General Secretary Mr. Tisara De Silva to give away the vote of thanks.
Thank you, Jamil. Well, as the General Secretary of the Organization of Professional Associations of Sri Lanka, it is my duty to propose the vote of thanks. President Mr. Sujiwalal Dahanayaka, President-elect Mr. Jayanta Galaheva, past presidents office bearers, EXCO and forum members, distinguished guest speakers, ladies and gentlemen. We have all benefited greatly from this seminar on the rule of law and the protection of individual human rights, organized jointly by the Seminars, Workshops and Programs Committee of the Organization of Professional Associations of Sri Lanka, along with the Bar Association of Sri Lanka. Given that this is a very vital topic that individually impacts all of us, as well as the society in general, this has undoubtedly been a very enlightening seminar. I would like to extend my sincere gratitude to Dr. Asanga Gunawansa, President's Counsel, and Dr. Lalanath De Silva, Attorney at Law, for being our guest speakers this evening. Your expertise and perspectives have greatly enhanced our understanding of this subject. Thank you, sir. I must thank the Chairman, Engineer Chamil Edirimuni, the convener, and the members of the Seminars, Workshops and Programs Committee for successfully conducting this seminar. My appreciation also goes to the BASL President, Mr. Anura Maddegoda, President's Council, and members of the Bar Association of Sri Lanka for jointly organizing this program. I also thank Mr. Chathura Galhena, Secretary of the BASL, for his presence. I would like to express my gratitude to the President, Mr. Sujivalal Dahanayaka, and the President-elect, Mr. Jayantha Gallaheva, for their leadership and guidance. I would like to extend my appreciation also to the Center Director and staff of OPA for all the assistance provided. Finally, I must thank the audience for your active participation.